Really, along with me is my business partner, Reddy Neumann. Today we're going to discuss about if you move to a different location, what should you do if you are on H-1B? What about the Perm labor certification? What if you are in adjustment of status? That's the main topic today. We're also going to discuss about if you are in adjustment of status, if you travel to India or travel outside the country and come back on advance parole, will you be considered to be on a H-1B or will you be considered to be an advanced parole or adjustment of status? What are the interactions where sometimes it is considered to be advanced parole, sometimes you may be considered as on H-1B? We'll discuss about those things. We're also going to discuss about the Congress people who have written letters. 39 congressmen from United States, that means the parliamentarians of United States, have written a very strong letter to the USCIS asking why there has been a delay in adjudicating the applications. And there's also a response from the USCIS. Not that that response is satisfying to me, but at least there is a response there. We're going to discuss about if the USCIS online status says that your name has been changed. The one that you check online, USCIS status check, where you see, oh, my H-1B says name has been changed. Is my name changed? Or sometimes it is address has been changed. We're going to discuss about that. Emily, with regards to if people have moved, let's say for example, they have moved from Florida to California, that's way too far. What should they do if they're an H-1B? What should they do?
Yeah, most of the time for an H-1B, that would require an amendment to be filed because your LCA that was submitted in support of your H-1B is only valid for the location on the LCA. So assuming that those two locations were not contemplated at the time your H-1B was filed, then before you can start work in the new location, your company has to get a new LCA for the new work location and file an amended petition. You don't need to have the amendment approved before you start working, but at least needs to be filed.
Emily, my job is not moving to California. It's just that I am moving to California, but I'm still logging in Florida. Do I still need an amendment?
Yes, so even in this whole COVID work from home situation, if your H-1B petition lists your home address as your remote work location and now you're moving to the other state, even though you're working on the exact same project, same end client, same job title, same everything, moving physically to a different location to sit and work from there requires an amendment first.
In the Perm application, Emily, let's say for example, I'm moving from Florida to California. Same scenario again. My Perm application is already approved. My I-140 is approved. I want to differentiate between consulting companies and non-consulting companies because you know consulting companies, they keep moving though. Let's speak about non-consulting company. Let's say I'm working for a company called Disney, okay? And now I'm moving from Disney, Florida to Disney, California. Do I need to file an amendment for the labor and I-140 for me to eventually get the green card?
It depends, short answer. So is this move permanent to where your job is no longer available in Florida and now is only available in California? Then yes, a new perm has to be filed and a new I-140 has to be filed. You can retain your priority date when you file that I-140. Now, if this is a temporary move where for now you want to try out California, but you have the intention of going back to Florida, Disney has the job offer waiting for you in Florida when you get your green card, then you don't need to file a new perm or I-140. The existing one stands. So it's all about where was the recruitment done. That labor market test has to remain valid. And so if the work location moves for the permanent position that you're being sponsored for, then that labor market test is no longer valid and it has to be done over again at the new location.
So if I have intention to go back to Florida and the company has the intention to take back, so practically I don't need to do anything.
Right.
So it's just the intention of that counts though. So even though I'm moving to California Disney, I have an intention to go back. Mm-hmm. And if people don't cooperate on that word, then they have to refile that. What about consulting companies though? Consulting companies, and we keep moving on. Let's say it's a Deloitte consulting company that I'm working with, and they move from one location to another location. What about that situation?
Yeah, for most consulting companies in the perm application, they specify that this job will involve working at unanticipated locations. So assuming that information is there and that the labor market test is then done at the company headquarters, even if you're in a completely different location when the labor certification is going through the processing, that's fine. It contemplates that this job may move anywhere in the country based on unanticipated locations, because we can't predict what project you're going to work on 10 years from now when you finally receive your green card. So in that situation, it's not necessary to file a new labor certification or I-140.
Emily, now same scenario, working with Disney, I filed a 485 application, it's been more than 6 months, it's pending. Now I'm moving to Disney, California. Do I need to do anything on the 485 other than filing an online AR11 changing the address?
Yeah, so if the actual job is moving, that is considered a material change. And in that situation, you'd want to make sure that this change qualifies for AC-21. Here, you need to have your 485 pending for 180 days, and the new job, which in this case is just a new location, has to be similar to the job that you were originally sponsored for, and you would submit a 485 supplement J.
Do I need to submit the 485J supplement though?
I think that depends on who you ask. I like to submit them.
I don't like to submit the 485J because, hey, it's the same job, similar job, and it's the same company. I don't like to submit the 485J.
Yeah, but to me, the work location has changed from what you were originally sponsored for, and so that should require a supplement J.
I don't want it. That's your opinion. Okay. Anything else I missed out on?
And yeah, I think that covers everything with the 45.
Now, here is a lot of people ask this question, Emily. We have the H1 and H4. We're only speaking about here H1, H4, L1, L2 guys, not anybody else. So these people, there is a presumption, a lot of people think that, hey, your adjustment of status is pending, you leave the country and you come back on advance parole. Can I extend the H-1B though? There are rules that says you can extend the H-1B. What about H-4?
Yeah, so that all of this boils down to a quite old memo that does say that once you return on advance parole, you are still eligible to extend both the H1 and the H4, same for the L1 and L2. The issue becomes, I guess the somewhat funny thing is, we have this memo because there were regulations that we've been waiting on for years for them to be implemented. So they gave us this memo to give us some interim guidance while we're waiting on the regulation. And the memo says this is in place until the regulation finalizes how we're going to deal with this situation. We finally get the regulation, completely leaves out the whole topic. So the question becomes, is this memo still good? Did the regulation change it? Did the regulation eliminate it? As of now, the memo seems to still be good, so that yes, after you come back on advance parole, if you're in H or L, you can extend your H or L. The question then becomes, what's your status from the time you enter on advance parole till the time you get that extension of H or L approved? Because the memo says you're considered to be back in H or L status once the H or L extension is approved. But what about in between? Nobody quite knows how USCIS treats
Well, one
that.
thing is that for all purposes, unless you want to refile the 485 application, you're good, you're fine. But if you want to refile the entire 485 application, that sometimes people do that. At that point of time, I normally tell them to go to Mexico, do the automatic revalidation because they have the H-1B approval valid, and they can go to Mexico and they don't need any visa to come back into the United States, because if you go within 30 days to Mexico or Canada, if you have a valid I-94, they can still come back. I tried this a couple of times and they had no problem. So if people want to refile their applications, then it becomes a point for them to actually go to Mexico and come back in this case. Oh, now we got a response from 39 Congress members at one point of time issuing a letter to the USCIS director asking what are they doing about the delays about this application. Who is this Congresswoman, Emily?
Yeah, she's actually from Georgia, and
Carolyn Burdock.
which is surprising because Georgia tends to be Republican, but she is a Democrat in Georgia. And on top of getting this response from USCIS, she's actually the one that introduced the employment authorization bill for H-4 holders.
What do you mean
recently.
employment authorization for H-4? We already have it, Emily. What is exactly this?
Yeah,
does?
so we have the regulation that allows for H-4 applicants to work when their spouse is certain point into the green card process, but that's just a regulation. She wants to make it congressional, as in statute based, so that the next administration can't try to eliminate
In other words,
this.
if the Trump comes in, he cannot eliminate.
Exactly. So that's part number one. But also, this bill does not require that the spouse be a certain way in the green card.
I-140, yeah,
So it basically treats an H-4 just like an L-2 would be treated.
and E3 visas too.
Yeah. So she did lead the charge in sending this letter to USCIS saying, what are you doing? Why are there so many delays? What are you going to do to fix it? And did get a response back from USCIS. Do you have any highlights from their response?
Nothing. It's the same bureaucratic response that says, hey, we are trying to do it. I'm not satisfied with the explanations what they have given. What they're telling is that we are short of people, we are short of technology, we are short of everything, but they are ignoring some of the things what they could have done is, for example, Emily, is to work more on adjustment of status. And also they can eliminate the interview aspects of it that they can do. I don't know if moving from Texas Service Center, Nebraska Service Center to the National Benefit Center eventually, in the short term, it looks to be fine. But I think so they should have fired some of the service center directors for issuing receipt notices 4 months, 5 months, 6 months off. 4 months after we file the 485 application. That would have resolved the issue. If somebody is not performing, they should leave the job. I mean, they should be fired, and that's what I think. So is some of the deficiencies. They're not taking very hard actions on it. Anything else, Emily, that you?
Yeah. So what I notice in this response is all for the last 2 years, every time it was, oh, it's COVID. We can't do this because of COVID. We're all working remotely. We don't have access, this and that. No mention of COVID at all as to what the delay is now. Now it's just, oh, we didn't have enough money, and now the president's budget, yeah, they gave us some money, but it's not enough. We have the Emergency Stopgap Stabilization Act that was going to help a little bit, but it didn't help enough. I thought it was COVID. Now all of a sudden COVID's gone and everything's great, and that they're still not performing. And then this really bothers me about the EAD processing. What can USCIS do to ensure workers do not lose their employment authorization while they're waiting for a renewal? They have the nerve to say, we created this great policy that allows L2s and H4s to get a 180-day automatic extension. And we'd also
they don't live
said
on this
L2s get EADs incident to status. That's going to make things so much better. And that was our idea. No, you got sued. that was
not the USCIS idea. It was they got sued by it. Yeah.
That really
Okay.
bothers me. Yeah, but otherwise it's just talk, no action. Talking about processing times and how you can look online to find out the status of your case. Great, yeah, but that tells you nothing. The online case status system is...
And then they always put the terrorist screening process. I mean, if you are letting these people in United States and if they are terrorists, you're not eliminating them from this country, that's something wrong. And you're making this 485 application pending for 3 years. That's not good. We don't want these terrorists in this country at all. So it's definitely all talk, no action. Definitely Congresswoman Ms. Products should try to go in a harder way to see if they can eliminate they can fire some of these USCIS people so that we can get a new leadership that can process these things very faster. Emily, with regards to this online status, we'll get the status says name has been changed. What does that mean?
Mm-hmm. Yeah, and it comes out of nowhere when you haven't done anything and the attorney hasn't done anything. So what does that mean? A couple of years ago, USCIS pointed out that no, this very likely is something that the officer did when they do the data entry from the paper filings, because we do everything on paper still, and then they have to manually enter that information, it's possible that there was maybe a typo in the address or a typo in the name or something incorrect there that the officer goes in and fixes, and then that generates this online case status update saying we've changed your name on your case or we've changed your address. So if you see that and it's not something that you proactively did, that doesn't mean there's a problem. It just means that whatever they did, it's internally within USCIS, and they were just updating the system to hopefully correct something that was entered incorrectly.
I have clients that are calling me and saying, I haven't changed the address from past 10 years. I've been staying in the same address. How come you changed the address? No, we didn't. we lawyers don't do that unless they get the written permission from the clients, guys. So don't scream on your lawyers. They didn't change the address. It is sometimes that happens, though. Let's go to the questions. One of the gentlemen is telling that his interview is scheduled, straight applications prior date is current, then they postpone it. That happens very frequently right now. They make it an excuse as a COVID, but I don't know about COVID. When I go to malls, when I go to movie theaters, when I go to airports, they're all filled up with nobody wearing masks right now. I don't know why it only comes for the USCIS officials, though. That part I don't know.
Patricia says she has a previous EB2 I-140 and her current employer filed the permanent I-140 EB3 and wants to know, should we file a new perm under EB2 or can we submit the AOS including both I-140s? So you can only submit the AOS based on one I-140, and that only is the one for your current employer, assuming that they're continuing to offer that job and you're not going back to the old employer. But that priority date has to be current. So you can't submit an EB2 I-140 approval from another employer and an EB3 I-140 approval where the date is not current and have that be the basis of your 485. So you would need to have the new employer file a new perm in order to get into EB2 with that company.
Pradeep has this question, wrote letters to the congressman. Thank you. He's on the 7th year of H-1B based extension based on non-profit based on the NIW I-140. Now his I-140 is denied. Can I work until 2023? Can I continue to work until a petition expiration date? Yeah, I don't see anything. Petition is already approved until January of 2023. One other thing, Pradeep, what you could do is that file an appeal for your I-140, and based on that appeal, you can extend the H-1B beyond January of 2023. So you don't have to, if you file an appeal is pending, you still are eligible for beyond 6 years extension.
Enkit has sent a letter to his senator and he wants to know, my H-1B extension notice has NMN written for my middle name, even though I don't have a middle name. Is that going to cause any impact during visa stamping? Totally normal. We started seeing that pretty recently. I think when they switched to that IOE for receipt numbers, especially for premium processing, the NMN means no middle name. So it's correct that there's no middle name since you don't have one. So just treat it as a blank space, no problem at all.
CG wrote letters. Thank you very much. EB3 to EB2 downgraded. I think so, it's the other way. EB2 to EB3 downgraded. I-140 approved, priority date is October 2011, which is final action dates are current. Do they have enough numbers to approve the EB3 cases? They have enough numbers to adjudicate all the applications that are pending as of December 31st of 2021. Because 30,000 cases were approved, 250,000 cases are pending. We have 290,000 cases, 290,000 numbers available though. So they do have enough numbers. They're just not working, that's all. And hopefully so, your letters will make them work. We already see a congresswoman like Ms. Bardox has already been trying to actually sponsor some things to divert these things like the load, because if automatic H-4 EAD, that will eliminate a lot of work for them. So keep writing letters, and that's all we can do right now. They have enough numbers to adjudicate, but if they don't adjudicate, all these numbers will be gone to waste, and you may be stranded out there for a long period of time. Whether or not to refile it, that's up to you. If my priority date is October 2011 and my I-140 is approved, I personally will not refile. That's me.
SG says, I got my EAD card, but my long name was cut short in it. Will it cause a problem if I travel? No, the names do get cut short. There's a character limitation on the EAD card, same as on approval notices and receipt notices, so that's not a problem. As far as travel, make sure you're aware that the EAD does not allow you to travel. You have to make sure it says serves as I-512 advanced parole at the bottom of it, because they are splitting those applications now, and sometimes they're only approving the EAD and the AP is taking a year to process. So make sure yours is actually an AP and that's what you're using to travel.
Priority date is January 2015. Is it good to file I-140 and 485 together, or is it better to get the I-140 approved? This question is from Sarvanan. Since your priority date is not current as of today, the first thing that I want you to do is actually file the I-140 in premium processing if the perm is good, and then get it approved, and then file the 485 application. Hopefully so in June you should be current, hopefully so. So definitely file in premium processing right now. I do not want I-140 and 485 going together because they go to our dear service center, Texas or Nebraska, which you don't want to. So if you file based on an I-140 approval, your application right now it's going to end up in National Benefit Center. So that's the reason why I want the I-140 to be approved.
Srinivas says his cousin has worked on an H-1B for 6 months back in 2008 and now wants to come back to the U.S. Will he fall under the cap exemption? And he doesn't have a copy of the H-1B. How does he get those documents? So yes, even though it was all the way back in 2008, if he only used 6 months of that 6-year allotment of H-1B time, he is exempt from the cap and can get another H-1B for 3 years plus 2.5 years for a total of 6 years when we count the original 6 months. Cap exempt can be filed anytime. Any company can file it. No issues there. As far as getting proof that he had a previous H-1B, probably a Freedom of Information Act request would be the best option there, unless he has access to the old employer and they have a copy of it that they can provide.
Arun has this question. He has downgraded from Eb2 to Eb3 in 2020. His I-140 is approved, Intrafiling February 7, 485J received, transferred to the National Benefit Center on April 21st. Can I change the job now within 180 days of Intrafiling? It's $1 million question. We really don't have an answer. We don't know where these people came up with this 180-day rule. It's not there in the regulation. It's not there in the law. So I would say that if you do move to a new company within 180 days from February 7th, because that's when you filed, not when you receive the receipt notice though, there is a 50% chance they may stick with you on the on the Eb3. There is a chance for it. So that's a risk that you're facing if you move to a different job. I would recommend under the conditions to actually wait for 6 months from February 7th, which probably will be 4 months from now. That would be more ideal so that you can obtain the Eb2 priority date.
Laxmi says, any approval from Texas for the I-485, or are they just only transferring to NBC? So we do have updated statistics on that on immigrationgirl.com. We have a whole post on tracking the October 2020 visa bulletin filings. Most of the recent approvals have all been coming from the National Benefit Center, 1 or 2 coming out of Texas. Some of those were 2012 filings that are just now getting approved. Did you say 2012? 2012, 10 years ago, finally getting approved out of Texas. But you can track that. I haven't updated this week's data yet, but I should be doing that tomorrow, so check that out.
Nikita Reddy from YouTube has this question. Wrote letters. Thank you very much. Did the Department of State or USCIS release the stats of approved GC in the second quarter? No, they did not. They did not. The first quarter they released in March, early March of 2000 and in early March. So most probably we may be expecting in July first week for the second quarter. And that's where the danger for us is we don't know how much they are approving it. They said they're adjudicating very fast, and all of a sudden they come and say we adjudicated 30,000 applications. Whoa, you got 30,000 pays. Not only that, you're going to waste 150,000 green cards, you're going to waste part of the 140,000 green cards, though. So definitely that's a very bad thing. And the other thing, Nikita, is that previously when they used to publish the 485 applications, though, they used to release the dates of which country nationals they are pending, what is their priority date, which month their priority date is. Right now, they don't release any of that information. They just release the information that these many 485s under the employment based are pending. We don't know if they're EB1, EB2, EB3, and if they are, what are their priority dates. It's completely, they don't release that. They used to do that before Trump administration, then they stopped it. If they would release that information as they used to do before Trump administration, we would have a better idea what's going on.
Mohammed says you got a new role that has a minimum change in responsibilities and duties. It's just a level up from the current role. Location is the same. Will I have to start the perm process again? I think this partly depends on the lawyer advising your company. Some attorneys are very conservative on that and say, nope, any change in the job, we have to start over. Others realize that, yes, jobs do change over time. Duties do expand over time, especially when it's several years that we're waiting from one step to the next, and would say, no, you don't need a new perm. And based on something like that, I would say, sounds to me like a new perm is not necessary. But again, it really goes down to the attorney advising your company.
Sirish has this question. I'm working for a consulting company, working remotely, changed client, and still working remotely with the other client. Does this case require an amendment? Assuming your job duties are similar, which I'm sure your job duties are similar, you haven't moved from software to a lawyer like me, you're in the same software field. If your physical location has not changed, you technically do not need any amendment. Having said that, Shirisha, though, sometimes when you go for stamping, though, they may look at it differently. Though. We normally recommend people who go for stamping to have amendment done. But as far as the legality is concerned within the United States, I don't see an amendment is required for you.
Volodymyr says the I-485 online case status says case was transferred and a new office has jurisdiction. Previously, it was at the Texas Service Center. What should I expect and when? And do I need to prepare and file the medical exam if it's not done yet? At this point, it's too early to say what needs to be done because we don't know if your case has been transferred to the National Benefits Center for continued processing or to a local field office. And you don't want to send in any medical exam until you know exactly where the file is. So you'll have to wait maybe a week or two. You should be getting a notice in the mail that tells you which service center or field office the file was actually transferred to. And then if it was transferred to a local office, that would suggest that you're going to be called in for an interview and you should bring the medical to the interview. I don't know if I would interfile it beforehand. If it went to the National Benefits Center, then you could interfile the medical once you know it's there.
Kishore from YouTube has this question. My priority date is current March visa bulletin, but my attorney through employer still working on preparing my case. What are my options to have my own attorney in this case? Well, one thing I can tell you is that your lawyer is very, very bad lawyer. If you get a tear in your skin, though, okay, the best person to go is to go to a doctor. Okay, don't go to the cobbler, the one who repairs the shoes, because he knows stitching. Don't go to the tailor. Okay, this is skin that has a problem. Your lawyer doesn't look to be an immigration lawyer. I don't know what he does. March visa bulletin. Now we are in May. He still did not file the 485. It's worth for you to change the lawyer. However, one point though, Kishore, one minus point though. Your employer has to approve that you can go to a new lawyer. Your employer has to give a 485J supplement. If he does not, you don't have an option. You have to stick with a cobbler instead of a doctor.
Harsh says, does the NBC start contacting the petitioner and applicant when the EB2 filing dates are current, or is it when the final action dates are current? So the NBC, meaning National Visa Center, this is when you're processing an employment-based case through the consulate, consular processing of your green card. Now, interestingly, it should always be the filing dates. The NVC and the Department of State, they're the ones that created this whole idea of the filing dates chart, because it was based on when they would in advance reach out to applicants to get the ball rolling, so that by the time the final action date is current, the documents are there and you can receive the green card. That being said, with COVID and budget and all these excuses they have, I think they're very behind on processing all the cases. So it would not surprise me if it has nothing to do with filing date or final action date. It's just whenever they happen to get around to it.
Pooja Jain from Facebook has this question. She is H4 EAD auto extended for 180 days. I've applied for the extension, but it's still in progress. No, Pooja, that's not right. There are very limited circumstances it's extended. For the 485 EAD, that's a Adjustment of Status EAD, if you file an extension, it is automatically extended. If you file a STEM extension, it is automatically extended for 180 days, but not true in the H4 EAD. There is something where they say it's auto extended because it's a little bit deceiving though. If your H4 is extended, then it is considered to be auto extended for 180 days. Let's say, for example, if your H4 EAD is expiring in June of 2022, you file the H4, and your H4 is also expiring in June of 2022. Let's say you file extension of H4 and EAD together, and both of them are pending. That means that after June of 2022, you cannot work. But there are some hackings. What people do is that if your husband's H-1B extension is approved until 2025, you can go to Mexico. While coming back, you tell that I'm happily married with this guy. Here is the H-1B approval until 2025, and they give an I-94 until 2025. In that case, though, your EAD is extended because your H-4 EAD extension is pending. You file the H-4 EAD extension before your EAD expired. Now your valid I-94 that is extended. So in that particular scenario only, you are eligible for the 180 days. We put a very nice video about a month or 2 months back. Please watch that. It's H-4 EAD extension 180 days. If you put it in the YouTube, you will get that nice 20-minute thing that if you watch it, you can extend it. It's called hacking, and you can do that very easily though.
Joel wants to know, can I continue to work on H1 after applying for a change of status to H4 and EAD? In most cases, yes. So assuming that your H-1B is valid still, let's say it's valid for another 2 years, and you're filing the H4 and the H4 EAD, wanting it to take effect maybe a year from now because the processing time is taking that long, you can keep working on your H1 as long as you're working for that same company and under all of those same terms and conditions while you wait. Now, if while you're waiting for your H4 and EAD to be approved, your H1 then expires and is not extended, at that point you have to stop working. Or if you lose that job and want to go work for another employer, you either have to file an H1 transfer or wait for the EAD to be approved. You can't just start working for the new employer based on the pending EAD.
Karthik from Facebook has this question. What are the disadvantages of using combo card while waiting for the green card currently on H-1B? Well, one of the disadvantages is that you will not be paying installments of your lawyer's Ferrari. That's one thing. It's definitely not a joke as I present it though. There are very less disadvantages. So we have put a very good YouTube on that. It's H1 versus AOS EAD. I want you to watch it though. Now here's the thing, Karthik though. When I was on EAD, I was a dependent 485 EAD. I personally let my H4 go in the drain and started using EAD. In fact, I was an immigration lawyer on EAD. Had I not used the EAD, nobody would have filed for my H-1B. Who files H-1B for a guy who just came from India, passed a bar? They won't file a H-1B. So I would have probably not been an immigration lawyer. I don't know what I would have been. I definitely use the EAD by myself. So I cannot tell you not to use the EAD, but when I personally have used myself. So it's up to your discretion what you want to do. I'm just telling what I did. There are some rare scenarios, especially if you have a teenage kid or if you are a teenage kid that may age out. That's one thing. And if there are some deficiencies in the I-140 applications, those are the scenarios. But I would say that less than 5% of the people require H-1B, but out in the market, you find a lot of these immigration lawyers telling, continue on the H-1B, continuing on the H-1B, and still extend the EAD. One of the major reasons is that, well, we buy cars, Ferraris. No, I don't have Ferrari, guys, but I'm just telling some of the lawyers, they want to buy Ferraris, so that's a very good payment, down payment for you keep extending the H-1B, we can buy Ferraris.
Oregonti says, can you travel to Mexico on H-4 while the H-4 and EAD extensions are pending? I also filed AOS under EB1 and that's pending. Does it affect any of these applications? It all depends on whether your current H-4 has already expired. If it has expired and you're in the US based on the pending H-4, you cannot travel. You need either the advanced parole or you need the H-4 extension to be approved before you can travel. Now, if you filed your H-4 and EAD super early and your current H-4 has not yet expired, then you could use automatic revalidation to go out and come back before your current H-4 expires and continue the H-4 extension process. There are a lot of people out there that are confused on this and say, oh, if I travel while my extension is pending, my extension is going to be automatically abandoned. That's not true. That used to be the case many, many years ago before I started practicing. Now the rule is a change of status, yes, that gets abandoned, but an extension of status does not get abandoned just because you leave while it's pending. But you have to have the valid status to come back on, otherwise that won't work.
Questions that are coming with regards to changing the lawyers because they're delaying filing the Foray application. Yeah, I mean, it probably is worth, because priority dates, they don't stay there for a long period of time. But definitely check with your company if they're allowing you to do, to go outside lawyer. Typically, our office timings are once you hire it, it takes anywhere between 7 days to 10 days to completely mail it to the USCIS, depending on your cooperation and as long as you are cooperative and all those things. Just want to make sure that your company is willing to sign the 485-day supplement though. Why does it take long, like 10 days for us? Most of the time is taken actually by the medical doctors though. They take a long time to give the medicals. That's the time that people waste a lot of time on it. One suggestion that I tell a lot of people recently that I noticed that these doctors, people are making an appointment with the doctors. You need to check with them how long it will take for them to give the medical reports. I have a couple of clients who have been waiting for months. I would file the application without medicals too, but because it may cause to issue an RFE and delay, that's the reason I'm holding them. You need to call the doctor in advance and ask them, hey, how long it's going to take for you to give my medical report. Some of them says that they don't have the vaccinations to be given, so come back after a month. After a month, your 485 priority date might go back. So call these doctors and check with them. How long does it take for you to give the medicals? Do you have all vaccinations required for me to come and get it done? Otherwise, don't go to the doctor. You have a lot of options. You can go to the USCIS website and you have a lot of doctors' options there that you can call them and inquire. It's definitely worth for you. Even if you spend about 2-3 hours calling these doctors, it's worth, because you need to know which doctors are going to give the medical. Typically, their turnaround time is between 3 days to 1 week. But if they say anything more than that, probably don't choose those people though. And some of these people will say, can you bring the 693 form? Don't go to those doctors. The reason why I tell you don't go to the doctors is it's like you coming to hire as an immigration lawyer, and then you have to bring your own form, which we don't even have our own 485 forms. So that's a very bad indication that probably the doctor doesn't even know how to fill the form out. So please inquire the doctor, check with the doctor. Normally, if they're giving in between 2 days to 1 week, they're very proficient in those things. They are the better guys that you need to approach.
Ganga says, I have done the biometrics during my concurrent filing with an amended I-140, 485, and 765. Now my new Eb2 I-140 and 485 and 765, will I be called to do the biometrics again? In most of our cases, I can't think of any where the person was called to do biometrics again. So they do seem to be reusing those as often as we file.
Venkat is suggesting news that there are 10,000 cases have moved out of Texas. That's right, Venkat, that's a very good news. We have been noticing a lot of cases getting moved out of Texas and also Nebraska Service Center though. That's definitely good news. But what is still bothering us is that the ones that we filed the I-485J to upgrade from EB3 to EB2, remember in October 2020, we all downgraded, and then guess what? The USCIS comes and said, we have too many green cards available in EB2. File the upgrade application. We file these upgrade applications. They are not getting adjudicated, and that is really bothering us the most. But yeah, it's a good news that we see that I-485s are getting moved from Nebraska and Texas to National Benefit Center.
Uma says, can we have two I-485s based on an EB2 and EB3, and after 180 days, can we port both of them to new employer based on AC21 by filing two 485Js? Absolutely, yes. If you have two different I-140 approvals and you are maintaining your non-immigrant status at the time of filing both adjustment of status applications, and then after the second one is filed, you meet the 180-day requirement, you can use AC21 and you can move both of the applications to your new employer at that time.
Atul Mehta, our priority date is current in May 22nd, May 2020 for EB2. What are you observing about the filed cases? Case has been moved to National Benefit Center. What could be expected and approval soon? Definitely any case which is moved to National Benefit Center, you definitely have an advantage though. But it's going to become current in May, so it's not yet current though. I don't know if the USCIS is going to adjudicate a lot of applications in the last quarter like the way they did, and then still wasted 60 to 70,000 green cards last year. If they would pick up more in the third quarter and do the same thing as what they did in the last quarter of 2021, which ended up in September 30th though. If they do the things in the third quarter, we may expect a lot of green cards approval, or we may have to wait for last quarter like the way we did it last year. So it's very hard to predict. A lot of people are asking, my case is here, my case is there. Can you predict when it's going to be approved? It's very hard, guys. I mean, it depends on the officer who has it, and we have no idea about that officer. One thing is for sure, we can see a trend that anything that is going to NBC is getting adjudicated much, much better than Texas Service Center. That's all I can. But there are some cases that we filed in October of 2020 that are still pending in National Benefit Center. Very less cases, but there are some cases. So it's very hard to predict, but if you are in NBC, you have a better chance.
Nilesh asks if there's been any success on downgrading approvals for Schedule A workers in order to consider for EB3 if those dates move forward. Yeah, Schedule A was kind of a big mess in October 2020. Everyone was wondering, can you downgrade? We didn't really have to think about doing it before. Filed several in our office, had several successful, had one denied unexpectedly. Filed an appeal on it, and that was ultimately successful. So it looks like it was very different between the two service centers, and some were approving, the other was denying, and then they went back and reopened those denied ones when it was based on them saying, oh, your prevailing wage has expired. That's what they were arguing. So they did reopen those and approve them, so we have been successful in those Schedule A downgrades, so it is possible in case EB3 dates move in the future.
A question that is coming out is, give me one second. Swapnil Shah's question, is it expected to have additional green cards in 2023 financial year, fiscal year? Yes, we are expecting extra green cards in fiscal year 2023 starting on October 1st. We yet don't know how many. We used to have the State Department that used to give all wrong numbers from the beginning. but we don't have them even giving any wrong numbers right now. But we do expect, though, because consulates are not fully functional in the world right now. In the family-based preferences, though, particularly the preference categories, though, most of the green cards are given outside the country, that is, in the consulates, though. They are definitely backlogged significantly, though. They're not working, they're not fully functional, though. Definitely, we are expecting those that are not used, that will be allocated, should and will fall into the employment-based. We are expecting in 2023. Now, here is one thing that people need to be careful on. Certainly depends on how many green cards they approve this year, though. The dates movement will be depending on that, though. So if they waste all 150,000 green cards that have been allocated, though, I'm not expecting the priority date movement. But if they adjudicate the 290,000 green cards that have been given, though, definitely we are expecting the priority date to move. Why did we went last time so wrong? Because they wasted 70,000 green cards. We didn't expect it. They said they're going to use all those things. So this time it depends on. So that's the reason why we want everybody to write letters to the congressman and to the administration. We have given the links there. Please keep writing letters. We promote the people who write the letters. We try to answer those questions who wrote the letters, guys. Kumar Keshavan, he wrote the letters, sir. Thank you very much. He traveled on AP. Can I do the automatic revalidation right now? Can I do it later on? His H-1B is expiring until 2024. We don't see any problem. You can wait for 1 year if you want to and do automatic revalidation. We don't see any problem. And thank you, Kumar, for writing the letters. You have taken the things in your hands. That's very good.
Praveen said his wife's application was moved to the National Benefit Center while his is still stuck in Nebraska and wants to know if that will delay the adjudication. We are seeing spouses and family members being split up for unknown reasons. And if you are the main applicant and yours is still in Nebraska, yes, that can delay because your wife's can't be approved until yours is approved. If it were the other way around and she's the main applicant, hers could be approved and yours could be stuck delayed. So it kind of depends on that situation there. And unfortunately, there's no way to force them to transfer a case to reunite the family members.
Vamshi and Vamshi has, yes, both questions. My case has been transferred from TSC to NBC. Is that a good news? Well, that is definitely good news. Then he asked the questions again. My case has been transferred from TSC. Same question. TSC to NBC is definitely a good news. It's definitely a good sign.
Internally wants to know, do we typically see a lag in the 485 approvals between the primary applicant and the dependents? I would say not typically, no, but it does happen. Most of the time when the main applicant gets approved, the family members are all approved together at the same time, and we see those status updates. We get the approval notices in the mail all on the same day. But in weird cases, sometimes they do get separated. And it's usually the main applicant gets approved and the spouse is pending for some reason, and it could take some time before they approve that.
Uruganti has this question. Does traveling on H4 for the I-94 extension, does it affect the AOS I-130 application? Yes, it definitely, there's a good chance, I would say that there is almost 90% chance that the I-131 will be denied, but you can refile the I-131 application though. It will not have any negative impact on the adjustment of status. It will not have any negative impact on the EAD application, but it will have a negative impact on the I-131 advanced parole that he's speaking about.
Rocky says, I got my GC EAD but never applied for the AP. Can I now apply for the AP without informing my employer? So the employer really has no part in that process. You can choose to file the AP on your own. You can choose an attorney to file it for you. Either of those is fine. You just need to have your 485 receipt notice in order to be able to file that. But yes, you can file it separately from the EAD.
Do you still file the I-140 and 485 together though? Is it a good option? Rajat, normally I do not, but it depends on the law firm though. When I say I do not, I mean In October of 2020, we did tons of them, hundreds of them. But now, though, I normally watch what is the priority date in May. If I file an I-140 right now, will I get this I-140 approval by end of May? That's one thing I will judge it. I will also notice that sometimes what I do is that I wait until the next month prior a visa bulletin comes in, and based on that, let's say for example, we are at May 12th and May 13th, we get the visa bulletin in June. And in June, the priority dates are still current, then I will file an I-140 first and 485. But if I'm in May 12th and the priority dates of June have backlogged, I mean, we can't file in June. So I'm not going to take a risk of getting the I-140 approval or receipt notice. What I would do is that I will definitely file an I-140 and 485 together. But if the next month the dates are moving, I would like to hold off filing the 485 application.
Phantom says, my priority date is January 2010. I'm applying for a GC from scratch through a new employer. The prevailing wage took 6 months. The labor and perm is going to be filed in May. When can I expect my green card? So the perm processing time is about 6 months right now. So you're looking at probably December before you get the perm approved. And then if you file the I-140 and 485 together, it could be another year from that point. So maybe the end of next year, assuming processing times for the 485 improve by then.
Crypto has this question, does promotion of a H-1B, promotion and a new H-1B affect the AOS already filed? If I'm your lawyer, though, it should not, because I see that as a natural progression in the job. I mean, there is a difference between the H-1B amendment as compared to that of the labor certification, I-140 and 485. They're very flexible in labor, I-140 and 485. They're a little bit less flexible in the H-1B amendment, but more flexible in the adjustment of status. It's a natural progression in the job, so that should be fine. I don't see that. That's my opinion, and that's most of the companies, including Facebook, Google, Apple, their lawyers also have the same expression that I normally do. So there are very less lawyers who will disagree with me on that.
Sarah Sruthi says, is there any impact for the perm or I-140 if the prevailing wage is higher than the current salary? It depends on whether, first, the employer has to be willing to offer the higher salary at the time you would be receiving the green card, so they have to agree to that. And then it comes up at the I-140 stage. If you're being paid less than the offered salary, the company has to be able to show they have the ability to pay the difference. So for that, USCIS looks to the net income or net assets on their tax return. So as long as the company finances are good, that should not be a problem.
One question that is coming from Rajan is that he's on Eb3 October 2015. I joined another company. They started the form. Definitely, Rajan, try to get it under Eb2 though. There are a lot of people that said, especially those people who filed I-1 labors and I-140s in 2021, they filed in Eb3, wrong decision. We always recommended to file the labor certification always in Eb2. When it comes to the I-140, if your labor certification is in Eb2, you could do it Eb2 or Eb3. But if you file the labor certification Eb3, the only thing you can do is Eb3. So try to get that into Eb2 labor certification, guys.
Ranganathan wants to know, what's the trend in interview waivers these days? He has an EB1A based on based AOS pending since October 2021. Biometrics are done. Priority date's August 2017. You know, for my cases, I can't remember the last time one of mine was actually called in for an interview. So the majority of them, I would say, are still getting the interview waivers, especially in EB1. For EB2 and EB3, we are seeing more and more people being interviewed, but still nothing anywhere close to what it was during the Trump years before COVID.
AOS is filed through EB1B, I-140. Priority date is November 2000. It is worth filing AOS again through husband's EB2. His priority date is November 2013. If you have the EB1B I-140 approved, Swapnil, absolutely I would not file another 485 if I were you. If the EB1B I-140 is not approved though, then definitely I will file a EB2 485 application based on your wife's 485 application. Because if it's approved, I will not I-140. That's the main criteria for me to refile the 485 application. Arun has this question: if you change the job within 180 days after interfiling, will they deny the 485 application though? I don't think so. That's my opinion though. I don't know where they came up. At the most, according to my opinion, you may be stuck with EB3, but definitely not a denial because you changed the job within 6 months.
Srikar interfiled from the EB3 to EB2 when the case was pending in California, and then it was transferred from Texas to National Benefits Center. Still no 485J receipt for the interfile. How can I ensure the 485 is considered under the EB2 category? And that's exactly what our experience was prior to this interfile specific form process that they came out in January. There was never any way to confirm when you actually were considered to be in the new category. With this new process, the supplement J should give us, the receipt notice should give us that confirmation that they at least received the interfile, but you haven't gotten that receipt either. I think the best way to do it is a Freedom of Information Act request to see if you can get a copy of your 485 file and see if it includes the interfile request anywhere in there, or reach out to your congressman to see if they can get that information.
Reno from YouTube wrote letters. Thank you. Received an answer for expedited request for the supporting. Do you recommend hiring a lawyer or submit the document myself? And there's not much the lawyer can do, guys. I mean, if I were you, I would submit it by myself. That's what I would do. Just because they requested the documents, that doesn't mean that they're going to approve it. But you should take a chance, and if I were you, I would file by myself.
Abid says his downgrade was filed as an amendment and wants to know if he can now file for a new I-140 under EB2 without the original perm and then interfile. Yes, so if you have your downgrade done as an amendment, USCIS confirmed that they treat that as if the EB2 approval no longer exists, but that perm labor certification is still valid, and you can use it to file an EB2 again, this time not as an amendment, assuming that it was not a success or an interest situation. And then once that you have that receipt, you can interfile to move it to EB2 that way.
Self-made has from YouTube. Can we travel outside country? Isn't it a burning of the I-485 application? If that may be true in a lot of cases, though. But when it comes to the H-1B, H-4, L-1, and L-2, that is not an abandonment. It's only if you are on B-2 visa, F-1 visa, U-1 visa, P-1, Q-1, B-1, A-1, those kind of visas are considered to be abandoned if you travel. But if you travel on H-1B and H-4, L-1 and L-2, you come back on those visas, you're not considered to have abandoned the 485 application. There's an exception only for H-1B, H-4, L-1, and L-2 visas.
Ramya says the derivative 485 receipt notice has her priority date instead of the primary applicant's priority date. Does it cause any issues? Yes, we saw that quite a bit starting from the October 2020 cases. Don't know why they're doing that, but it does not cause any issues. Haven't had a problem with that yet.
Good question. What is a good time frame for filing a mandamus for I-485? 2 years, 3 years, or 5 years? This is where the things have been pending for a long period of time. I would definitely, where you file the case in the court requesting the judge to order the USCIS to adjudicate the application. I am more leaning towards 5 years though, Ravi. And believe me, there are cases that are pending for 5 years. But if you have any more questions, so you can contact our litigation lawyer, whose name is Stephen Brown at RN Law Group. He'll guide you. When it comes to the EAD though, I mean, even if it's pending for more 4 months, it's probably worth taking the USCIS to the court though. Only I-485 EADs. I'm not speaking of H-4 EADs, just I-485 EADs.
All right. Well, I think we're out of time for today. Thanks so much for joining us. As always, we'll be back next Tuesday at 5 o'clock Central Time. Please don't forget to subscribe to our newsletter by going to rnlawgroup.com, and you can also check the status of the pending 485s and what we're getting approved in our office here by going to immigrationgirl.com.
And the link is provided there for the Immigration Girl in the bottom there. Thank you, guys.